Professor Capron has one of the longest CVs I have ever seen, and there is apparently no padding in this document. Just a few highlights. Currently, he serves as the Director of Ethics, Trade, Human Rights, and Health Law at the World Health Organization in Geneva, Switzerland, the first person to hold this position. In joining the WHO in October 2002 to launch the Ethics and Health Initiative, he took leave from the University of Southern California, where he is the Henry W. Bruce Professor of Equity, Professor of Law and Medicine, and Director of USC's Pacific Center for Health Policy and Ethics. Professor Capron is the president of the International Association of Bioethics and has served on a number of national and international commissions and organizations that deal with ethical issues in medicine. From September 1979 to March 1983, he served as the executive director of the President's Commission for the Study of Ethical Problems in Medicine and Biomedical and Behavioral Research, and in 1997 was appointed by President Clinton to the National Bioethics Advisory Commission. Since 1981, he has been a member of the Institute of Medicine of the National Academy of Sciences, on whose council and executive committee he has held positions. This, I assure you, is only a small slice of his institutional affiliations, which just the institutional affiliations alone take a whole page of his bio, single-spaced in small print. He is the author of 10 books and dozens of articles. Professor Capron has written and commented on virtually every key issue relating to ethics, medicine, and health, including genetic engineering and testing, reproductive and therapeutic cloning, stem cell research, surrogate parenting, and the end-of-life issues, to name just a few. The initiative Professor Capron leads at the World Health Organization addresses on an international level the ethical and policy challenges arising from the development and delivery of diagnostic, preventative, and therapeutic health systems. These challenges include equitable access to the treatment and care for HIV and AIDS, which is a top priority, and issues arising from organ transplantation. In nominating him for this lectureship, one of our faculty members told me that there is no one in this country today who knows more about the policies and politics of world health. Focusing on the international scene, Professor Capron's topic today is difficulty in doing bioethics globally, ethics law, and human rights in the UN system. Please join me in welcoming our guest.
Thank you very much, Dean Bartlett. There are always times like that when I know the only people who would have been interested in this would have been, your introduction would have been my parents, who would have been pleased to hear it. The rest of you suffered through. It's a great pleasure to be here on this lovely day. And it's a particular honor for me to be giving the 5th Seymour Siegel Lecture on medical and legal ethics. I not only knew Rabbi Siegel, but alone among those who preceded me to this podium, and I suspect any of those who will follow me, I can say that I worked for Rabbi Siegel. That is, he was one of the commissioners appointed by Ronald Reagan to the President's Commission for the Study of Ethical Problems in Medicine and Biomedical and Behavioral Research, of which, as you've just heard, I was the executive director. Seymour was a man of great learning and deep convictions, and we all benefited greatly that he brought those to the deliberations of the President's Commission. So in thinking about what topic I might address on this occasion in his honor, it seemed fitting to take our work together on the President's Commission as the starting point and to think aloud with you a little about what has taken place in public bioethics since the early 1980s. And then from my present perspective at the UN agency that is charged with the responsibility for world health, to reflect on how my thinking has changed from this global perspective. Now, the dean told me I could expect a mixed audience, some from law, some from public policy, perhaps some from medicine or science, and a general interest in ethics, but not necessarily a specialized background. So this is not, in that sense, an academic paper. Inevitably, I will be somewhat anecdotal and personal as I am in showing you this picture, for those of you who have never seen it, of the World Health Organization in Geneva. This is our multi-building campus. That's the central building. And I do hope that in the process I will be able to leaven this personal analysis with some critical thinking to provide a structure for our understanding of the developments that I'm going to canvass. So the question then is, how and how well is bioethics carried out in the UN system? And I plan to address this through three topics. I'll begin by saying a little bit about what is bioethics and how is it related to human rights. Specifically, I want to look in some detail at the claim that bioethics is really a branch of human rights. I'll then say a few words about doing bioethics in public. What does that mean to be doing bioethics? What are the characteristics of the process? And finally, what are the challenges in doing bioethics globally? And specifically, how well do the mechanisms used by WHO and UNESCO fulfill the goals of public bioethics? Bioethics is a familiar term. It's something which one sees regularly in the newspaper. People are identified as bioethical commentators when issues arise about end-of-life care or stem cells or cloning. What does it mean, and where did this term come from? Now, it's obvious that medical ethics itself is as ancient as the practice of medicine, and indeed one is more likely to look to Hippocrates for his ethical guidance than for the science of medicine. But it wasn't really until sometime in the 1960s, it seems to me, that several forces came together to create what became identified as a new field. There were, on the one hand, startling developments in the biomedical sciences and the clinical application, not only in genetics, but in behavior control, and of course in transplantation with the first heart transplant. There was also a generalized assault on authority in many fields. The civil rights movement, the consumer rights movement, women's rights, and so forth, all brought challenges to respective aspects of our daily lives, and particularly of the governing structures. And in our particular area, there were challenges to the professional dominance of doctors in particular in the physician-patient relationship, and to what is sometimes referred to as the generalization of expertise, the notion that somehow on issues of science, medicine, and even health policy, that one ought to defer to physicians. The statement in the middle of a conversation, well, as a physician, I think kidneys should, or machines should be allocated this way or that. Well, as a truck driver, I think. I mean, why as a physician? What did that add? Well, it was that the sense of a field which just having the medical degree was enough. And the challenge of bioethics was to say, no, this is a set of issues in which there is as legitimate a place for public institutions and for public, the civil society, and for individuals to be part of a decision-making process, and we shouldn't be thinking of this as something in which we have to defer to physicians. And then out of this, a few people from a variety of fields, not only medicine and the life sciences, but also behavioral and social sciences, theology, philosophy, and the law, came together and began to collaborate on projects to explore what kinds of issues arose, how they could be dealt with, and this gave rise to the term bioethics. Today, what does the term connote? Well, first, I think there are a set of standards or duties that attach to the actors involved. This, one could say, is the normative aspect of bioethics, and it includes some quite specific instructions as well as a general sense one might say, a continuation of that ancient tradition of ethical obligations, of the fiduciary relationship between the physician and the patient or other health professionals and their patients or clients. Secondly, a field of inquiry concerning the issues that are raised by the developments in the life sciences, by research with human subjects, and by the provision of health services and public health activities. Thirdly, I think bioethics connotes what it has from the outset, which is an interdisciplinary approach to these issues, drawing on moral philosophy and theology, the social and the life sciences, medicine and the law. And as I'm going to say in a few moments, there is some challenge to that view, against that view today. But I think that most people in the field, and including some who are here who are practitioners, would say that interdisciplinarity is still a hallmark. And finally, that this has always been, and is probably today as never before, a field of public discourse. And it's this aspect of public bioethics that I want to come back to in a few moments. Now, some leading bioethicists, such as George Annis of Boston University, have suggested that bioethics is actually best understood as a branch of human rights, and therefore that bioethics should look to the rights articulated, the principles articulated within the human rights declarations and covenants for its own global principles, that this is the best and most reliable source of those principles. I think there are at least three reasons for rejecting this thesis, and I call them the identity argument, and I believe, as I will try to demonstrate to you, that history shows that bioethics and human rights were not twins separated at birth, but that they are distinctly different. That the focus argument as to whom each field addresses, and the subject matter argument that they actually have rather different areas of concern. Yet, while they may not be the same, they are complementary, and of course I have come to feel that even more decidedly in my role as the director of the department that includes not only ethics, but also human rights as part of its responsibilities. Now, the argument for identity that's put forward by Annis and others rests on the central historic importance of the judgment passed by the U.S. Military Tribunal in August of 1947 on the Nazi physicians who had engaged in medical experimentation in the doctor's trial. And this judgment was explained in convicting 17 of the defendants. The explanation for why their conduct amounted to crimes against humanity. The judges summarized what they took to be 10 basic principles governing the action of physicians engaged in research. And they recognized in doing so that research with human beings is a legitimate part of the medical process, but only if done in accord with these principles. And those 10 principles became known as the Nuremberg Code. Now, that was not strictly an international document because it was an American military tribunal, but it has been treated as such, it was regarded as such by that court and subsequent courts. And indeed, the argument is that's put forward by Annis is that from the Nuremberg Code, one can trace many of the subsequent human rights conventions that have been adopted. And he would argue, likewise, beginning in the 1960s, these same themes underlay the development of bioethics, so that these common issues and ideals can be seen by now to have come together in a recognition that bioethics embodies and should be based on human rights norms. Now, the argument against that begins by saying that yes, the judgment at Nuremberg was a fundamental human rights document. And we can see that its consent principle, for example, appears in Article 7 of the International Covenant on Civil and Political Rights, and it can be read as addressing a basic ethical issue, whether we need to prevent risks to all research subjects or to ensure special protections for vulnerable populations. And I would say that reading it as a human rights document, in a way, springs from the latter reading because you can say that most of the human rights documents are written with the notion of vulnerability and the need to confine the actions of the state, command the actions of the state against others in a way that protects that vulnerable population. And thinking of the prisoners who were both German nationals, who were gypsies and Jews and homosexuals who were in the concentration camps, and those prisoners of war who were in the concentration camps, you can see their special vulnerability. And that non-discrimination approach is also embodied at a time when the general right to health came in to be recognized. WHO's Constitution was adopted the same year. The right to the highest attainable standard of health is articulated at the beginning of that Constitution as the principle on which the Constitution rests. Subsequently, in the Universal Declaration of Human Rights, the right to a standard of living adequate for health and well-being is one of those to which everyone is entitled. And since then, non-discrimination in health care has been recognized in other conventions, such as the Commission Against Discrimination Against Women, the Convention on the Rights of the Child, and so forth. Yet what is startling is in the post-war period, these human rights documents were seldom even noted, much less relied on, in the development of medical ethics and bioethics. And the clearest example of this is something which many people cite as the natural successor, but I think is more accurately seen as something which was drafted in reaction to the Nuremberg Code, and that is the Declaration of Helsinki, which the World Medical Association began drafting in the 1950s and adopted for the first time in 1964, obviously in Helsinki. It was really created because the doctors in that association, made up of the national medical bodies, principally then from Europe and North America, but eventually from the world, intended to reclaim in a document drafted by and for physicians that role of self-governance, which they regarded as central to the profession, and to distance practicing physicians from the Nazi criminals. And so they said, put the Nuremberg Code on the shelf. That was a judgment against a group of people who engaged with state sanction in barbarities. We have none of that. Those rules are not relevant for us. Most of our research is going to take place in the context of patient care, and we need special privileges. And if you read that document, the original 64 document, what is striking is how in the context of research combined with patient care, the obligation even to provide consent is carefully guarded. And it's stated basically when possible, given the psychology of the patient, you can tell them what's going on. Now, research with normal volunteers, the obligations more clearly mirror those of the Nuremberg Code, but even then, the notion is this is a physician's document and we're dealing with the usual forms of professional dominance. The notion that that is a document about human rights misconstrues it. It is a document, yes, about physicians' obligations, but while we may say that obligations and rights are just flip sides, it is not a patient's right document. So what did account for the growth of bioethics? Well, the notion of informed consent first appeared in the California Appellate Court decision in Salgo versus Leland Stanford Junior Board of Trustees in the late 1950s. In the 1960s, we had, as I said, the series of startling developments, competition for scarce kidney dialysis treatments, the definition of death issue arising, particularly in the context of heart transplants, issues around abortion. By the 1970s, new reproductive technologies, prenatal diagnosis, psychosurgery, and the scandals in human subjects research, particularly the 1972 revelation of the 40-year history of the Tuskegee syphilis experiment. Then, in the early 1980s, issues of the AIDS epidemic and questions of gene therapy. And I would say it was only with the beginning of the AIDS epidemic that people began to think more explicitly in rights terms, in human rights terms. And again, it was because of the vulnerability of this particular subset of the population. Most of you are too young to remember, but there was a time when Haitian immigrants, along with gay men, were the two feared groups because it was the unusually high prevalence of the disease in those populations that caused them to be singled out. And in a number of states, the adoption of statutes designed to protect the information as information which was clearly potentially very damaging if revealed. So then why the lack of identity? I think that when we think of human rights, we have to think of intergovernmental negotiations, the thinking behind this, largely led by lawyers and continental philosophers, very much embroiled in the Cold War struggles, the splitting up of the Universal Declaration into the Covenant on Political and Civil Rights, and on the other hand, favored by the West, and the Covenant on Economic and Social Cultural Rights, favored by the East. This was part of the Cold War. Obviously, that has no correlate with bioethics. Bioethics, in contrast, there it goes, grew out of Anglo-American common law and very much Anglo-American analytic and moral philosophy, and it addressed the new capabilities of biomedicine and the limits of medical authority, not state action. So if I were to redraw Annis's picture, it would be the Nuremberg Code leading on the one hand to the development of human rights, on the other hand to the development of bioethics. Out of human rights, by the 1990s, we see a clear recognition of human rights as a basis for health development and public policy, and very much in the UN system, a recognition and acceptance of the role of human rights. On the other side, we do see rights-based theories joining principalists, consequentialist or utilitarian, and feminist theories as explanatory frameworks for bioethics. Whether there will be interplay between the two of these is the issue, but I don't think that it makes sense to say that the two are one and the same. And indeed, treating bioethics as the twin or even as the direct descendant of human rights is historically implausible. That does not, however, answer the question, which is would it be helpful to reformulate bioethics as a human rights field? And to answer that question, I think we need to look at the focus and subject matter arguments. What is the domain of human rights? Well, as I've already suggested, we have to be careful not to use the term every time we think somebody should have something. Well, they have a human right to this, a human right to that. We really have to talk about human rights as norms, standards, and principles that are generated by governments with universal scope and applicability and enforceability. And they primarily are about the relationship between the individual or perhaps groups and the state. For example, to elaborate the International Convention on Economic Social Rights, Article 12, which talks about the highest attainable standard of health, the Committee on Economic and Social Rights issued a general comment in 2000 that spells out the three types of duties of states parties: to respect rights, that is to say not to deny or limit access to care, to fulfill the rights through legislative arrangements, budgetary support, and to protect the rights, preventing third parties from interfering through discrimination or harmful acts. Thus, human rights may indeed reach private conduct, and you can think of those state obligations and private acts where they overlap are private acts from which the state must protect people. And that is as true in the health area as it is in any other area of human rights. In contrast, the focus of bioethics is essentially about private actors, with the state being, I would say, more in the background. The basic framework of legal rules and procedures to allow private parties to relate to each other and carry out functions is a role of the state in this field as in any field. But the ethical norms largely grow out of a process that will be enforced by the professions and through funding and licensing decisions, rather than centrally being state issues. And if you look, for example, right now there's this big crisis about this Korean apparent fraud with cloning and stem cells. And the investigation was carried out by Seoul National University. Another one is being carried out by the University of Pittsburgh. Now, in the background is the sense that the government may be involved if there was a outright fraud and the misuse of funds. And of course, the Koreans are particularly sensitive about this because they had adopted Dr. Hwang as a national hero, put his face on postage stamps, given him free lifetime first-class travel on Korean Airlines and so forth. But the government is pretty much in the background with that. And the real hand-wringing and the questions, what did we do wrong, what can we do differently, is coming out of the scientific community. What do we do if peer review can't catch these kinds of problems? Do we say, was never intended to? What happens is, if you can't replicate a study, you figure out it was done fraudulently, and we have to live with that? Or do we need greater access to the raw materials so that people who are doing the peer review can get it right? Big ethical crisis, international scandal, and so forth, basically being responded to, it seems to me, within the professions, and those people in ethical and policy positions involved with the professions. I'm not saying this is professional dominance all over again, but it is not centrally a government activity, other than if there have been government funds that have been used, and in the Korean case, sort of the sense of national shame that requires some government response, and particularly because he had involved the government's central health advisor as a nominal co-author on one of the papers, and the sort of the suggestion of suborning her support. So when dealing with justice issues such as fair access to health services, which would be the closest interaction with something that is directly a governmental human rights sort of concern, it seems to me that bioethics limits itself to asking, how are we fair? Become very proceduralist, rather than is it your right to have something, which is the human rights response. Likewise, if we look at the subject matter area, it seems to me that the subject matter area of human rights is a broad stroke legal norm governing state conduct. For example, the obligation of the state's parties to progressively realize the right to health. Whereas bioethics has produced guidelines and rules, you might say, well, that sounds similar, but it often does much more. And those of you who come from the medical side will know that a lot of time in bioethics is spent with reflection about the issues on how to respond on a more refined level. And in fact, one of the things that I'm going to say a little bit about later, I hope, is a report that came out of UNAIDS and my department and the HIV department last year about guidance to countries on the ethics and equitable access to HIV treatment and care. And that is not a human rights document. And the interesting thing to me is we wove a little bit of human rights in, but we were cautioned by people at the country level. If you want to talk to governments about this, if you put it in human rights terms, they're going to get their backs up. But they all want to do what's ethical. And so make this an ethics document. So we go through an ethical analysis of the various theories that would explain why you would decide one arrangement or another is fair, and what is a fair process, and so forth. And we try not to make it a human rights document. So sometimes, oddly, even ethics is more palatable than human rights. The major task of bioethics is not to issue rules, however, it seems to me, but to examine the dilemmas, particularly where we have clashes and conflicts between goods. It's easy. I mean, one ethical issue for a lot of people around the world today is corruption in the healthcare system. If you're dealing with a healthcare system that's stressed, the so-called red envelope, the payment under the table to the doctor, is a big part of reality into who gets care. And that's an ethical issue. But it's not an ethical issue because it's a dilemma. It's a dilemma on this health system. How will they have the adequate ability to treat people and to make the system work well enough so that the doctors can practice there instead of running off to their private clinic where they'll treat the patients privately. You do have a health policy issue. But it isn't a dilemma whether corruption is bad. It is a dilemma to ask, what about trading off protection against people's lives being taken involuntarily against the right of people to have access to means to take their life painlessly if that's what they want to have? There you have a dilemma. You have good arguments on both sides. And that's the kind of thing that bioethics exists precisely to deal with because of those kinds of conflicts. Bioethics creates expectations for reasoned analysis and careful weighing of the competing concerns, not recourse to authoritative treaties or other rules. And beyond that, there's the whole area of nuanced examinations of relationships, professional-patient relationships, parent-child, individual society, that take, as much as they can, full cognizance of the psychosocial dynamics of those relationships and recognize that simple legal rules are not going to be the answer. And my colleague and mentor, Jay Katz, has written beautifully and tellingly and convincingly, but I'm afraid not yet affecting all physicians' behavior, on exactly that problem of communication. Because of the ethical traditions of the professions, such as the Hippocratic Oath, when these issues are analyzed and the duties are identified, it is in ethical rather than human rights terms. And so I would conclude that there is a complementarity. They're not the same, but absolutely, human rights can make a positive contribution to health development and public health. And in large measure, bioethics will point in the same direction. And indeed, as I said, when we were doing the document on access to HIV treatment, we used human rights ideas. We just didn't label them as such very often because what the countries wanted was to know what their ethical obligations are. And I do think, conversely, that there is a lot to be lost were bioethics regarded as simply a branch of human rights, or we started talking principally in rights terms in bioethics. Nevertheless, I think it's worthwhile, and if this were a medical audience, I would spend more time on the chart I'm about to show you, because this is something that our human rights team has developed to show the three areas in which human rights interacts with health. Obviously, there are human rights violations that result in ill health, like slavery, torture, harmful traditional practices, and violence against women. There are also ways in which the promotion or violation of human rights can occur through health development: the right to information, the right to privacy, the right to participation, and freedom from discrimination. And then we can reduce vulnerability to ill health by using human rights. The right to health itself, the right to education, the right to food and nutrition, the right to water are all things which, if implemented by a government, will in fact reduce vulnerability and therefore improve health. So then let me turn to the second part of the talk, doing bioethics in public. Now, obviously, from what I've said thus far, it is obvious that this is different from a pure analytical, philosophical, academic approach to bioethics. But I would also say it's different from doing bioethics simply with public support. From its earliest years, bioethics had some support. There was a little bit of money from NIH, from NSF. Now in Europe, there's a good deal of money. I think in the current year, there'll be about 5.5 million euros. And euros are big deals now, in case you haven't noticed the exchange rate. From the European Commission for bioethics. For the most part, none of that is really that different, however, from a study that's sponsored by the Rockefeller Foundation or the Gates Foundation or the Ford Foundation. To me, that's sponsorship. It doesn't make it public bioethics. Public bioethics is also not simply front-page bioethics, not the pundits being asked, what about this latest startling development? To which the answer is usually, yes, this is an interesting subject we have to think more about, and society hasn't caught up in its ethics with its science or its medical practice or whatever. The phrase doing bioethics, I think itself suggests the difference. And thinking back to the time when I knew Seymour Siegel, it seems to me that we did not use the term doing bioethics in the early days when there was an academic exercise or even one of these interdisciplinary think tank things at the Hastings Center or at the Kennedy Center, nor is the work of being on an institutional review board or a hospital ethics committee called doing bioethics. It seems to me instead doing bioethics had the connotation of something that was an activity in the public sphere, and because it was public, there were certain obligations, but there were also certain constraints imposed, both at the type of activity that was sought, not abstract advice, but something more concrete, and also the constraints of having to conduct oneself in public. And that is very decidedly true of those presidential commissions. Now, I'm not going to explore certain aspects of this topic. Are commissions used as dumping grounds by the executive branch or the legislative branch for things that are controversial? They can say, oh, the commission's studying it, and then not have to worry about it. Are they, in fact, a lightning rod to deflect the anger of electrified groups, interest groups that are out there? These would be interesting topics to explore, and if Seymour were here, I'm sure he could add to his sense of whether people were appointed to those commissions because of a reflection at that time of one or another of these views. I think of the chairman of the commission, originally appointed by Jimmy Carter, who served through the Reagan years, Morris Abram. Some of you may have known Morris or know of him, a Georgian who had become an international lawyer in New York, a very prominent member of the Jewish community, and someone whose bout with cancer, very public bout and experimental treatment and so forth, was, I think, the reason he was attracted and asked President Carter to make him the chairman of that commission. And a person whose politics changed enough to make him a regular visitor to the Reagan White House. So this is an interesting story. Contrast that with someone like, but he had no real background in bioethics when he was appointed. Contrast that with Leon Kass, who has just stepped down from running the President's Council for President Bush, a person with a 30-year history of writing and taking very strong positions. My predecessor at this podium as a Siegel lecturer, a very different view of what the role of a member or chair of the commission would do. Instead, I want to look at what it seems to me is the legitimate aim of doing bioethics at the national or global level. And I want to identify 4 characteristics of public bioethics. First is accountability, have to answer to the public. Second is accessibility, that the processes and results of deliberation are visible and understandable. Third, agreeability, by which I mean that the results command wide agreement both among the group producing it. These commissions and committees typically do not have lawmaking powers, so if they are seriously divided, unlike the Supreme Court, their word is not final, they have to persuade. And fourth, applicability, by which I mean the practical relevance of what is said. And all of these are important in doing public bioethics, but I'm going to argue that the latter two are of special significance in global bioethics. When we turn to the global side, the challenge lies in trying to meet these 4 qualities of good public bioethics. And my conclusion is that it's considerably more difficult to do bioethics well globally than it is nationally. And I want to recognize as a caveat that this difficulty may simply reflect other changes that have occurred. I mean, my experience obviously began with the national form of doing bioethics. You could say, well, if today the world is very different, the field has been professionalized both at the clinical applied end and at the theoretical end. It's now being claimed by many people in philosophy and theology schools as basically this is our field. If you want to get a PhD in bioethics, you would go to a philosophy department. That's a change, and it means that the work that's produced is more sophisticated, but not always more useful in terms of the real world. Let me give you an example, which I listed there. The question of making living wills effective it's been a bugaboo for years. We've had the construct of the living will by which a person can give the instructions as to how they want to be treated at the end of life, even if they are, or when they are not particularly able to say at that time. It's very difficult. Many people don't fill them out. They don't communicate very well. If I'm dealing with this with physicians, my message is all about communication. How do you make that document useful to the patient and to yourself? How do you communicate what you'll do with it? How do you get the patient to explain reasonably what the patient will do with it? Philosophers and some lawyers examining this are fascinated by the philosophical question of identity. Is the person lying in the bed now unconscious the same person as the one who filled out the document? Well, obviously, you look at it and say, well, yeah, that's Alex Capron. I mean, what's the question? Well, but that's not Alex Capron in the circumstances Alex Capron was in when he filled that out. It's a different person. And therefore, the document is as irrelevant as if it was written by someone who didn't even know him. How can Alex Capron know the interests of that person? We should therefore disregard the document. Interesting discussion. An added complication to the utility of living wills. Maybe it's one of the reasons that we have practical difficulties with them. That certainly is worth exploring. But it's a totally different issue than the real issue for physicians and patients, it seems to me. And that's happening with a lot of issues in the field these days. There is also good empirical work that has gone on. So the field has become much more complex empirically. Unfortunately, there has also been a pronounced growth in ideology and politics. And Robert Cook-Deegan, who's in the audience, and I experienced a little bit of that in the mid-1980s when I was chair and he was the unfortunate director of a panel as a successor to the President's Commission set up by the United States Congress, which the panel was able to operate. The senators and representatives who appointed us were not able to. And when a vacancy occurred and they had to agree on a replacement, they were unable to do so, and the whole thing was caught up. So even back then, there was some ideology in politics, but it's gotten a lot worse. Now, Art Kaplan, who is a well-known figure in the field, has recently argued that this is a reflection of the increased clout that bioethics has. And he says this is really, it's at the level now of the debates that have gone on for years about who lost China. Those debates in the 1940s and 50s, very vitriolic debates, entered into the McCarthy era arguments and all the accusations. I think Kaplan has it wrong here. I don't think the political aspect of the debate shows that bioethicists have the kind of clout that the old China hands and the foreign service people had. I do think it reflects a journalistic tendency to cover any issue as a battle if they can, rather than getting into the subtleties. And it's also true that bioethics provides a good battleground for some politicians in fighting the culture wars today. But in any case, maybe that and my increased age and therefore frailty explains why I think doing global bioethics is more difficult. But I think I'll try to show you some of the problems that arose and how, to telegraph my bottom line here, how the addition of human rights has actually made things more complicated in meeting our 4 A's. So the difficulties with accountability. The first, of course, is the question on an international level, to whom is one accountable? There are obviously, oh, that's a typo, the formal processes exist within intergovernmental organizations. They all have means of coming to conclusions. But the different organizations have potentially their own constituencies in the governments. For example, we at WHO relate to the health ministries. UNESCO relates to the culture, science, and education ministries. UNICEF is not run in the same way, but obviously relates to many constituencies. The Office of the High Commissioner on Human Rights, the Human Rights Commission, FAO, and so forth. The question, do these participants represent the real stakeholders? For example, Just to give you an example, the committee that deals with bioethic issues in the Council of Europe has vigorous debates on a lot of these topics, and they are quite stringent in imposing bioethical responsibilities in treaties and protocols. These are real documents. They are debated out and hammered out to the comma because they, once signed by a country in Europe, will become an obligation to adopt national laws to the standards set there. And what struck me in being at many of these debates is when they got to the topic of mental patients, suddenly everything changed, because who's in the room? For the most part in the room are departments of justice and sometimes ministries of health. And they were fine on telling researchers and doctors all the things that they should do. But mental patients are usually a responsibility of the judicial system and the mental health system in the country. And suddenly the countries themselves were the addressees of these injunctions that were going to be put into law. And in that case, they became very much more reticent about expanding in any way the obligations. And the argument that we, in, say, Germany or France, don't recognize this in our country was enough to scuttle it as something that should be included, rather than saying, well, you should go there. That should become your standard. Oh, no, if they say, we don't do that, well, we can't put that into the document then. So how can bioethics be accountable in terms of producing results that are useful? Again, we have to address simultaneously high, medium, and low income or resource countries. We address countries with very strong religious views, which in themselves may have conflicting religious views, as I would say the United States does, and those without religious views, very sectarian countries. Are the processes and the results of deliberation going to be visible and understandable? The second characteristic of accessibility. Now, in some ways, you could say this is a contrast with my experience with the Federal Advisory Committees Act, which I actually think is a very important act. And all the commissioners I knew thought they could never hold their meetings in public. They would never say anything. Within minutes, it's like Fred Wiseman and his documentaries and the cameras. People forget that they're there. And if they remember that the public is there, they actually elevate the quality of their thinking and discussion because of it. But they're quite able of going on. Now, we in the UN system claim that what we do is transparent, but there are a lot of unseen and unmentioned political and other influence exerted on our experts and committees, and there is therefore a tendency to favor topics and tasks that are not going to upset the states and donors, but instead will bring favorable attention to the agencies. Moreover, the greater sophistication that I've mentioned in the field of bioethics tends to mean that the results that are considered good quality bioethics in an academic sense are going to be of less interest and relevance to the public and the representatives. Now, as I said a few moments ago, it's when we get to the third topic of agreeability and the fourth topic that I think we have particular problems. And here, results do not achieve consensus in the process or command-wide agreement among audiences is my bottom line with many of the things that we face. And the problem, as I said, is exacerbated when we add human rights. Now, think, for example, of the UN's inability to adopt agreement to negotiate a treaty banning reproductive cloning despite having approved UNESCO's Universal Declaration on the Human Genome and Human Rights. Or the unresolved tensions between cultural pluralism and universal rights in their recent declaration on bioethics and human rights. Or for myself, the internal problems we faced, because I don't want to point the finger only at UNESCO, when we were putting together a guidance document on intravenous drug use and HIV. We had incredible internal problems getting the people from the HIV department to work with the people from the substance abuse department. They each saw this as their own territory, one dealing with people who take care of intravenous drug users in either a prison or a mental health system, the other dealing with the system that is trying to build up treatment for HIV, and having that internal tension bridged was a problem. Let me give you some more details on the other two. The Universal Declaration was adopted in 1997 by what UNESCO calls the International Bioethics Committee, but it is obviously by its title, although a bioethics committee authored it, a human rights document. human genome and human rights. It's problematic in many ways. It has language about the genome being the common heritage of mankind. The implications of that are frightening. It means all of us are carrying around something to which everybody else has some equitable interest. It also declares acts which violate human dignity, such as reproductive cloning, shall be forbidden. Now, the General Assembly approved several years later this declaration. So it isn't just a UNESCO declaration. It was approved by the General Assembly. But a year after that, when France and Germany came forward and did what they thought was going to be a very simple matter, there was a lot of attention. Remember, the Raelians were saying, we've got cloning babies coming right along, and a few U.S. reproductive health doctors were saying they were able to do it too. And so France and Germany went to the General Assembly, and the General Assembly asked its legal committee, the Sixth Committee, draft a treaty, or agree to draft a treaty that will outlaw reproductive cloning. There isn't a country in the world represented in the UN that didn't say they were against reproductive cloning. 4 years later, the body, having already endorsed the notion that reproductive cloning violates human dignity, was unable to adopt that and ended up adopting another ambiguous declaration against all forms of cloning. And here's the ambiguity: inasmuch as they are incompatible with human dignity and the protection of human life. I want all the first-year law students in the room to write an essay explaining the double meaning of inasmuch as. I mean, it either means to the extent that or since. So the US took the view, of course, it means since. All forms of cloning, including research cloning, are incompatible with human dignity. The French and Germans and others took the view, oh no, if it is incompatible, then you can't do it. But the British, of course, have recently licensed cloning, and they went along with this, this declaration. There's another example in Article 12 of the new UNESCO Declaration, which is called Respect for Cultural Diversity and Pluralism. You can see the text here. If you notice a slight tension between these two sentences, you're reading them correctly. On the one hand, the importance of cultural diversity should be given due regard. This is a strong sentence. Due regard is weak, but should, for this document, is strong. They use a lot weaker terms. However, such considerations are not to be invoked to infringe, et cetera, on human rights. Well, the obligations are obviously very vague, which duty bearers are supposed to do what, but they only have agreement on pluralism as a principle by saying that its manifestation, that if its manifestation is inconsistent with the other principles, then it's disallowed. So what kind of pluralism does this give us when most of the issues in pluralism, such as the role between men and women in society, are indeed ones which other human rights instruments try to strike down? Now, let me give you what I think is a contrary example. Our approach to this issue of agreeability is to focus down. And in 1991, the World Health Assembly adopted some guiding principles on human organ transplantation. And they basically are aimed at preventing commercialization and trade. That was the real issue. And they looked at the world as it then looked. And so 13 years later, the World Health Assembly said to my department and the department that deals with the technical side, go back and look at these now. Has the world changed? And the world has changed in terms of the greater use of living donors, both in the West and in the developing world, where it's the principal way in which organs are obtained. So what we're doing is developing a global alliance on transplantation and focusing in on living donors. I think the bottom line here is that by being context specific, we will continue to be able to give useful advice that has wide acceptance. There are many other WHO documents, like the list of essential drugs, that have ethical implications, and then these are in turn interwoven with other agreements for other global organizations, the World Trade Organization, the World Intellectual Property Organization. We've just been through a multi-year process which has led to a radical revision of the international health regulations. that recasts the relationship between WHO and member states. The range of illnesses is now open-ended instead of just the 3 classical illnesses. The sources of information, we can now look to non-governmental sources of information in reaching judgments, and the actions that we can take. The specific duties that are embedded in that document include measures that will address public health threats that are as least restrictive as possible in human rights terms. And that concept, very familiar to American lawyers, is now built in. So we take human rights, but we give it the specific context of who's the duty bearer and what actions they are permitted to take in light of the risk of the circumstances. Finally, the duties in applicability. This seems to me the essential quality. The results must have practical relevance to be doing public bioethics. If the addressees don't think the conclusions have relevance, that's a problem. If the conclusions can't be formulated that apply equally well in all circumstances, that's a problem. And if the guidance that is given at the level of non-binding declarations is inherently vague and general, that's a problem. Let me give you examples of all of these. So the first is, what is the relevance in light of other guidance? In the new Universal Declaration on Bioethics and Human Rights, Article 15 talks about the sharing of benefits. And this is apparently related principally to the issue of the results of research, and there's a huge literature on the issues of what do you do to individuals and communities who have participated in a research process. And those different kinds of things you could give them are listed, and I don't give you the full list, but they're listed in the declaration. And then there's the statement, benefits should not constitute improper inducement to participate. Well, if you look at these two, you say, they may both be talking about benefits, but they're talking about totally different issues, and they are cabined together in this particular article. One is the broad sharing of results. The other is overwhelming researchers or communities with goodies that get them to act against their own interest. But it also gives you no hint on how we're supposed to combine this with the World Intellectual Property Organization rules or to the human right to moral and material benefits of one's creativity, which is embodied in the International Covenant on Economic, Social, and Cultural Rights and is recognized as a human right itself. If you have that right to own your property, what does it mean to say any scientific research should be shared with society and with the international community? The second thing, by way of difficulty with applicability, as I said, is trying to cover all circumstances and ending up saying nothing that is binding. Now, in this case, it's important to keep in mind that the declaration apparently covers medicine, life sciences, and associated technologies as applied to human beings. In other words, everything in medicine and the life sciences. It says it's addressed to the states, but also, as appropriate and relevant, decisions and practices of individuals, groups, communities, institutions. So in other words, doctors, patients, hospitals. Okay, so what are they told they have to do? Article 3 says human dignity, human rights, and fundamental freedoms are to be fully respected. The interest and welfare of individuals should have priority over the sole interest of science and society. And then Article 10 goes on to make a justice or equality claim about the same thing. The fundamental equality of all persons in dignity and rights is to be respected. Okay. So does this apply to individual patients and physicians? When I see my doctor, do I have to worry, am I getting treatment that other people aren't getting? Have I violated an obligation of justice? Has the healthcare institution? Does it matter if it's other patients that this doctor sees who are not going to get his attention because he's with me? Or does it matter if it's in the community I live in or the whole globe? The notion that the interests of the individual should always have priority of the sole interest of science and society is language which appeared in the original Declaration of Helsinki. It makes a lot of sense in the research area. The doctor should not take his patient and make the patient a stepping stone for the good of others. But applied here to public health, the question is, if we have a public health emergency, don't we have the right to take the interests of society over the interests of the individual? Do you have to give consent for isolation and quarantine? Of course not. It's not consistent with public health law, but apparently it may be an issue under the Declaration. And an issue that was highly debated and on everybody's mind these days, embryonic stem cell research. Would it advance human dignity to have embryonic stem cell research to come up with cures of incurable illnesses and help human beings? Or does it contradict human dignity because you destroy embryos? The United States, which had rejoined UNESCO just recently, sought to have the phrase human life included with human dignity that would be fully respected. Instead, it wasn't successful, but it issued its own interpretation, which says respect for human dignity and human rights requires respect for the life of human beings. The Declaration doesn't define what qualifies as a human being or when human life begins, so the US interpretation is as good as anybody else's. In the end, what do we get if we have high-sounding principles with no real applicability? And the third and final is that basically non-binding declarations are inherently general and vague. Generally in human rights, we need steps that are taken to respect, fulfill, and protect these enumerated rights. And they have to be specified. Who are the duty bearers and what do they need to do? The Declaration does the opposite. In the document, all the musts have become shoulds, and in the meeting of the so-called experts, intergovernmental experts last summer, all the shoulds, or a lot of the shoulds became are to be. For example, Article 5 says, autonomy of persons to make decisions is to be respected. For persons who are not capable of exercising autonomy, special measures are to be taken. Doesn't tell me as a health minister, if I look to this document, what I should look for in a national law. Now, this is one of the most interesting and controversial statements. It was, however, adopted enthusiastically and without, as far as I can tell, any recognition of the inherent controversy. The statement I want to focus on is that the risks should be, the benefits should be maximized, and any possible harm to such individuals should be minimized. Now, the harms include patients. Obviously, harm minimization in research is as old as Nuremberg. It's stated repeatedly. Makes perfectly good sense. But in medical practice, we know therapeutic options are tried all the time that are very high risk, and they're tried because of the expectation of benefit. A language of proportionality is perfectly appropriate. A language of maximizing the benefit to risk ratio, but not a statement that says harm to individuals should be minimized. Now, to try to look at a different document, I've already mentioned this document, which was our guidance about the factors that are relevant in achieving equitable access. We try to analyze for the countries the meaning of equity and explain which policies would therefore run afoul, but this is a guidance document. It's not a normative document in setting forth standards of what must be done because the circumstances in the countries will vary between those that have public health systems and those that rely principally on non-governmental organizations to provide health care or on private health care. Within that context, there's going to be debate about the substantive principles, and therefore we explain how one can go about having a fair process, a concept that has been well developed both in human rights but also by philosophers like Norman Daniels. So my conclusions then is that there are many challenges in doing bioethics globally that go beyond what happens at the national level, that human rights declarations are at best a starting point and sometimes may complicate achieving appropriate results, that it's still very worthwhile to overcome these challenges because the policies and activities in question need an injection of bioethical analysis if they're going to be just, respect persons, and achieve a sustainable benefit. And most important, it seems to me, that we must continue to work globally so bioethics can overcome its own 1090 gap, that 90% of the bioethicists spend their time worrying about the ethical issues that are relevant to 10% of the world's population. So thank you all very much. If they print out any copies of these slides, you'll be able to see my contact information. And there again is your view of Geneva. Thank you.
I want to thank you, Professor Capron, for a talk that was staggeringly comprehensive and wide-ranging and complex and subtle and very fascinating. Thank you very much. Thank you all for coming. I'm sure Professor Capron would be happy to take your questions outside the room. We have a reception and a chance to mingle and enjoy one another's company. So again, thank you for coming and thank you.